Hey, good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is February 14th. Happy Valentine's Day. We will take the roll.
Thank you, Mr. Chair. Commissioner Bowe, Commissioner Gonzalez,
Here.
Commissioner Hackett, Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Nanjapa, Commissioner Robbins.
Here.
Mr. Chair, you have 4 out of 7 commissioners present.
Okay, great. And 4 is a quorum. And I believe that this morning we have one item on our agenda, and that is to hear from a heartfelt and tired staff from all the work that they've done over the course of the last week or so in putting out yet another red line to the financial assurance rules. And I believe we have Director Murphy with us and perhaps AAG Stafford. And I believe we've got several slides that we will listen into, and we will hear a presentation on the most recent draft that was published on February 11th. Director Murphy.
Thank you, Chair. And hopefully folks can see my slides. I think I have commissioners and AAG Stafford queued up so I can see all of you. So when I go off the rails, everybody can bring me back in. Today is going to be a more lengthy presentation because what I've done is built in staff's proposed revisions based on your initial feedback from January 31st and February 1st into that document or into the PowerPoint presentation that we finalized on the 2nd of February. So if you'll bear with me, I'll just jump in. So from that kind of first round of direction, we went through a number of different elements. I've maintained that order except for one, and you'll notice an F and G, and in the green font, you'll note that I swapped these two. As I'm going through the rules, it made more sense to talk about them together because of the rule provisions hang together, and it made the presentation a little bit more orderly. So, you know, where we are today, black text reflects the feedback from commissioners, blue text reflects the direction from the 31st and the 1st of February, green text reflects where I think we are today. So I'm trying to help us keep this all together. When I show you draft language from staff's draft rules, they're literally snips of a PDF document, not showing the red line because the red line makes it really hard to get it on a single slide, much less interpret it. So just kind of wanted to set out some of the ground rules. I'm going to jump into the Orphan Well Fund and fee in just a moment and just say that as I had the opportunity to reflect over the weekend on what the commissioners have put together, I think it's a comprehensive approach that does represent a paradigm shift. I know that more changes are likely to come as we work through the different permutations of some of the conversations and feedback from stakeholders, but it really is a multi-layered approach to the question that, to me, most importantly, incentivizes operators taking care of their own retirement planning, right? That's our number one goal. Financial assurance is a backstop to that, and a backstop to financial assurance is the Orphan Well Fund and fee, which is why I wanted to touch on this here. And so to me, whether you like the belt and suspenders description of that kind of scenario, or whether you prefer something else, I was going to look for some funny cartoon about it, but I just didn't have time. I just want to reframe that as I look at these rules and as I think about especially kind of the production thresholds driving the different financial assurance tiering, it really does tailor the approach to incentivizing operators to maintain production from their wells. So with that, I'll jump now into creating the Orphan Well Fund and fee. The direction from these different slides is largely it's all in Rule 205. Most of the heart of it is really in 205C. So the goal that the commission set forward is to generate approximately $10 million a year in year 1 and year 2, and then come back and revisit the funding, take a look at where we are in terms of federal spending, take a look at where we are at in terms of the number of orphan wells or the scope of the project, scope of work remaining. And so one of the fundamental questions was kind of working with stakeholders to establish equitable collection across different business models. I will say I have not had the capacity to vet what you saw in the draft language, or you're going to see in the draft language with stakeholders. I hope they can find a way to work 6 words into a slide of a thumbs up, thumbs down, whatever, for staff's different approaches. There's a number of comments in the SBP, which we're working to finalize and hope to get out soon. And so jumping now into the meat of Rule 205C3A, what the approach that I took in this is to generate approximately half of the $10 million through a per well fee. So it's about $100 a well. And then I laid out 3 different options based on staff's culling of the data within our system. You could do a fraction of cents per foot of the total measured depth, a fraction of cents per foot for the total vertical depth, or using a 1 cent fee on production. And we used it based on barrels of oil equivalent. For those of you who care about the data, this is the data that we pulled. Using today's daily activity dashboard, we have approximately 49,000 well bores in the state. Mr. Ellis pulled together our production over the last 3 years and averaged it. And then Mr. Holder put together our total vertical depth and total measured depths based on looking through our different reporting mechanisms in the system. A couple of notes in terms of what wells were included and what wells weren't. We didn't include wells that were never drilled, wells that have not been drilled, or wells that have been plugged and abandoned or were drilled and abandoned. One thing to think about, and this was one of my team's wise suggestions, is that if we want to make, instead of using fractions of a cent, if you were to select total measured depth or total vertical depth, you could also convert it to per 1,000 foot of vertical depth, and that might make the calculation a little bit easier. And so those are kind of the different metrics. I wanted to be sure to include the actual metrics that we were using in case folks want to think about a different ratio, right? Maybe 75% should come from total measured depth, and the balance should be made up from either production or the number of wells. Anyway, I wanted to give everybody the tools to understand how we were viewing and how we would calculate the numbers. Moving a little bit on, the direction was to make clear that the annual registration fees would only be expended to fund orphan wells and sites. So that language is proposed in 205C5. And then this is the amnesty discussion. It ended up covering a number of different provisions across the rule series. The lion's share of the substance of it is in Rule 205D. And then important like kind of procedural mechanisms are built out in 503G13, H7, 504B12, and 505F. And so looking at that language now, staff put together a voluntary relinquishment program that would be available until the end of this year, December 31st. We chose December 31st without your specific direction because it lines up when, under the current draft rules, the last tranche of initial financial assurance plans are due as a result of this rulemaking. And so to me, it made more sense to have a voluntary relinquishment come in lieu of or in advance of initial financial assurance plan coming due. The hearing requirement is built out in 503G13, clarifying that the commission, not ALJs, are going to address these hearings if they come up. And notice goes to the director, and sworn testimony is not required to support the application, though the application does need to be verified. So that's how we put the program together. I think the commission direction was clear that it needs to be for a fixed period of time. It needs to encompass the entirety of an operator's assets. And we also need to revoke or to claim financial assurance. So we've tried to build that in again in 205D, with supporting concepts throughout the rest of the rules. And then moving into kind of the administration of the Orphan Well Fund and Fee. 205C6 addresses annual reporting. We built in language that identifies the direction that you all provided around the commission itself revisiting the fee and the fund every couple of years. Historically, I've been anxious about putting in regulatory language that regulates the commission or commissioners. But I think that if it's appropriate here to set out our expectation of ourselves, I get it. And then we made some, and then they're the just kind of general process regulations. So running through those, staff's Orphan Well report, reports on plugging, remediation, reclamation through the fiscal year, which ends June 30th for us. Identifying the total number of orphan wells and sites that have not been plugged or closed out, funding received and funding spent. And again, the language in 205C3D would focus on, or focuses on revisiting the fee amount every effectively 3 years in terms of when it would change, but taking a look at it every 2 years to see if we're kind of on the right trajectory based on the dialogue amongst the 5 of you. In terms of the process, our direction would be that the first filing would be due in August of this year, but rolling into the following years, we would like them by April 15th. Tax day is a great day. It just helps set up our budget rolling into each year and helps us account for that, for the influx of funds in coordination with the report. So it makes the rules more administratable for us. And then a couple of pieces of information requirement that would be included in the form and hopefully straightforward for operators to insert. And that, my friends, wraps up element 1 on the Orphan Well Fund and fee. I can just kind of roll through this. I trust all of you to raise your hand or give me some sort of, bat signal if you want to chat about anything along the way. But I do have a lot to get through, so I'm going to try to power through. So turning now to addressing federal wells. I'm not going to spend a lot of time walking through the different slides. There's a lot of detail on those slides. We were able to reduce the majority, I think all of the direction into a single paragraph in Rule 702A1. And the general overarching goal was to create a path to consider federal wells within COGCC's financial assurance, providing a bit of an on-ramp to that process that would accommodate the federal process, which we have built in as well, but no later than October 15th of 2023, we want these plans to be, we want operators with federal wells to build a financial assurance plan that encompasses those federal wells. And so with that, I'm going, and that the director or the commission can determine whether federal funding is insufficient, and some important SPP language about other governmental entities that may also require financial assurance. That's SPP language. So turning now to the language itself, again, it's in 702A1. And so it requires that the operator will provide financial assurance no later than 90 days after the effective date of any rule adopted by the Bureau of Land Management, and in no case later than October 15th, 2023. And at that point in time, operators will need to come in with a revised financial assurance plan that the director or commission can determine whether the financial assurance required by the federal government is substantially equivalent. And if it's not, what additional financial assurance would be required, so long as we don't duplicate financial assurance. If anybody thinks that that's not the most artfully drafted sentence, I claim authorship of it, and I'm happy to see revisions or improvements to it. But I think it's trying to deal with a couple of pretty meaty, pretty important topics that the commission worked through. But I also, there's no pride in authorship. So that's the federal well topic. So we're really cruising through these fairly rapidly, which is amazing. Turning now to the element discussing different definitions, element 2. This is going to be a little bit of a deeper dive. So starting first, with the definition of inactive well. One of the directives that came out of this discussion is actually incorporated into Rule 702C for the different, no longer tier, but now financial assurance options. A directive to integrate an average 1 BOE or 1 MCFE production threshold into the definition of inactive, and then include some important language in the SPP. Another piece is to build in the opportunity to either petition a well in or out of in an active status. We've built that into 434C2. And so turning now to the definition of an active, this is the one place where as of today, I've identified one of my mistakes, which was we inadvertently excluded the definition or a shut-in metric or a shut-in time period to roll a well from shut-in to inactive into an inactive designation. That was an error. So we would strongly recommend that the commission build that back in. And I believe Caitlin's put together language if anybody wants to see it. And in our enthusiasm for building in this production threshold. So one of the important things I want to spend a little bit of time talking about today is the difference from barrels to BOE and MCF to MCFE. We've talked about, and the rules that I've helped put together use all four of those different units, and they all mean very different things. And as we're getting now to the final stages of this, I think it's important to understand how we, the commission, expect the calculations to be performed to get from barrels to BOE, MCF to MCFE, and take care of the other pieces of production. So in my lay way of describing it, BOE is a way to calculate from a well and incorporate both its oil production and gas production into a single metric. Barrels only describes the oil produced, MCF only describes the gas produced. But many of Colorado's wells produce both. And so how do you account for both, given that both are likely to be sold or utilized at this point in time, given the flaring restrictions? To do that, the number that I have been using to convert from MCF to BOE or barrels to MCFE is 6. As I look back through some of the stakeholder comments, 5.8 jumped out at me as ones that had been used by other folks. These rules propose that conversion factor between MCF to barrels, or sorry, MCF to BOE and barrels to MCFE of 5.8. But what it doesn't tell you is to understand which, whether MCFE applies or BOE applies to a particular production stream. And so going back to how industry tends to calculate the difference between a gas well or an oil well when there are more than one type of production, if you will, or commodity produced, they focus on the gas oil ratio. And so I'm going to jump to the next slide, which describes how staff has used and applied the gas oil ratio for any number of years. This slide actually pulls from a presentation from November 11th of 2018 around how to classify wells on the Form 5. So all of our wells are classified as either oil wells or gas wells. That is based on the gas oil ratio. And so the gas oil ratio is calculated by dividing the MCF of gas produced by a well by the barrels of oil produced by the well, and then multiplying by 1,000. A gas well that has a GOR greater than 15,000, a well that has a GOR greater than 15,000 is a gas well. Less than 15,000 is an oil well. My understanding also is that there are industry standards that use something more like 10,000 to distinguish between gas and oil wells. APCD has different regs. If you look at EPA's regs, there are multiple categories of heavy oil, light oil, wet gas, dry gas. Because this is what Colorado has used for, or the Colorado Gas Conservation Commission has used for quite a while, I felt the most comfortable recommending that we use the 15,000 threshold. But I recognize that folks might disagree. And so coming back, I'm going to go back up to the definition of inactive now to kind of refocus this, which is trying to figure out how to make the calculation to understand whether a particular well is above the threshold or below the threshold. So first we need to define what kind of well it is. If it's an oil well, it would use the 1 BOE threshold, and gas would be integrated into BOE. If it's a gas well, the oil would be converted to MCF and the MCFE threshold would apply. So that's a lot of math on a Monday morning at 9:22 from somebody who's a lawyer by training. So it's super dangerous, but happy to go back and revisit it. And then I will go ahead and flag as we move into the discussion of 702 and the production thresholds. Again, that's another place where the commission integrated an operator's average production in both BOE and MCFE thresholds. So we have a slightly different approach to the suggested calculation in that, which just uses aggregate data instead of having to do a well by well calculation. So we can come back and talk about this anytime you want. It's scintillating, certainly. But with that, I want to jump into the provisions related to inactive wells. In working through, and so this is moving away from the definition of inactive and into the process or substantive related components of inactive wells. A couple of different things. We tried to simplify some of the reporting requirements for temporarily abandoned wells because of the transition or the implementation, we hope, of 434C that requires an operator to return a well to production, plug the well, provide financial assurance, or designate the well as out of service within 6 months of becoming inactive. With that, I think with that focus, we think it's less important to get an annual Form 4 on temporarily abandoned wells that restates why they're temporarily abandoned and also what the methodology is used to keep them temporarily abandoned. So the way this draft rules would work, which we think is a more implementable way, is that within 30 days of temporarily abandoning a well, the operator submits a Form 4 notifying the commission. That notification timing hasn't changed. Staff has built out a little bit more into what needs to come in, which is how is the well closed to the atmosphere, essentially. Clarifying that it needs to be maintained in that condition while it's closed. Again, eliminating the need for that annual Form 4 going forward, but maintaining a requirement that within 6 months after being temporarily abandoned, the operator needs to submit a follow-up Form 4 saying this will continue to be shut in and why. And then at 12 months after temporarily abandoning the well, the operator would need to either plug, produce, bond up, or designate as out of service. So again, trying to like line up these different timelines and make for simplified but straightforward filing requirements that we can use to track. And again, all of these pieces are also complemented by the commission's expectations in financial assurance plan to be reporting out about inactive wells and how many there are and how they're going and what plans are for the future. So I think all of the information will continue to be collected in a way that can be meaningfully digested. But long story short, getting another Form 4 for each T8 well didn't seem like the best use of time given the other filings related to temporarily abandoned wells. So with that, turning now to the 434C2 language, and this is the opportunity to petition a well into or out of inactive status. And so again, the 5B is what comes in for a temporarily abandoned well a year after it's been temporarily abandoned, or for a shut-in well, assuming we do include the language that staff inadvertently excluded, 18 months after the well is shut in. So the 5B comes in, and that's mandated with specific types of information. And there's the opportunity for the director to designate wells as inactive. And there's also a 5C, which would be the operator's opportunity to request an exception from the designation as inactive. And again, that's 434C2. Turning to the definition of low producing wells, this might be the quickest slide I go through today because it was make a correction, leave the definition alone. So we made the correction, which is the language shown in black bold with the following definition and not bold. A couple of things to keep in mind. The definition again uses barrels and MCF, not BOE and MCFE I don't know if that's important to you all as you roll through it, but it's a distinction that I wanted to flag because it's different from how the production threshold is calculated in the definition of inactive wells in particular. I also wanted to flag the places where we use the term low producing well. It's used in the context of what type of wells are being transferred, the certification process for a relevant local government or surface owner to request a 211 hearing. And then again, information planning in the context of 702C and financial assurance plans. I'm a little bit anxious, to be perfectly candid, about having two different production thresholds that are treated slightly the same, but slightly differently. It may be cleaner to pick one place for a production threshold and then incorporate it appropriately. But what we've put together in the draft rules incorporates your direction and is certainly implementable from our standpoint. Turning now to the definition of out-of-service wells, out-of-service plugging list, out-of-service location, out-of-service facility. We've made these definitions conform to the language that we've proposed in 434D. And I'll get to that a little bit later. Talking about the definition of single well financial assurance, this is a place where I think probably is appropriate for the most thinking and stakeholder feedback of a number of the topics that are still really trying to be developed. The direction was ultimately to leave staff's draft as is. And I think, we're looking for a bit of a unicorn in this and something that's simple to calculate and understand, but also representative of, or close to representative of costs. And that's quite a task. Our teams have spent a number of hours over the past 10 days, and we'll continue to be thinking about it this week about how best to do it. Included here is the definition of single well financial assurance. We did make a couple of small what I think of as administrative changes to the definition to make it more readable and functional. I think that there are a couple of key takeaways that I would encourage you to think about. Trying to come up with a straightforward estimate that can be tailored with actual costs. I think it is important to think about the differences between the reclamation and the plugging, right? Those are, they serve different purposes, and lumping them together, though that's how we've done it, may not be the best approach. And candidly, when I was putting the rules together and defining this term, I picked single well financial assurance because we've always thought about financial assurance on kind of a per well basis. Given multi-well pads, maybe carrying forward that historic practice doesn't make as much sense in this context. And should we be thinking about a single location financial assurance that encompasses both the location and some plugging costs? I think, there's any number of ways to do this successfully. And so I'll be interested to see what stakeholders come forward with based on the dialogue from you all. And I guess my 2 cents on how to best do this. Again, our team is continuing to work on it and think about if we can come up with an appropriate estimate that would work statewide on this approach. Turning now to element 8, which is the hearing process components. I think we didn't receive any guidance on changing the definition of used and useful or 211 itself. We did get direction on the 503 G12 language. So turning to that now, we incorporated the language from the Brighton group with some, again, what I think of as administrative changes that conform to kind of how we draft rules, as well as the functional change requiring certification of conferral, not just consultation, as a requirement before the application can be filed. I hope that this works for that group. Again, I did not have as much time to reach back out to stakeholders as I had hoped to kind of get feedback before Friday evening. So turning now to the second component of the hearing processes that we worked through, and this is participation in financial assurance plan hearings. I think we did get, some fairly clear direction that the operator is always a party, commission staff's a participant, CPW, CDPHE, and relevant local governments can participate in a more limited capacity. Drafting the language for CPW and CDPHE was a little bit more difficult because it's easy to understand what is within a local government's jurisdiction, right? We have geospatial boundaries for that. CDPHE and CPW have broad statewide authority to do things, very different things. And so we tried to work on language that tied the jurisdictional component mostly to the relevant local government. And can build in the statement of basis and purpose language around CPW and CDPHE for kind of like their spheres of expertise, perhaps. Just wanted to flag that we had kind of an interesting experience drafting that. But again, the language relevant, I think the most relevant language is in 504B10A and 702B3 and 4. And probably. So now shifting gears yet again today, talking about single well financial assurance for some or all wells. Again, this is a place where I think that there's still a lot of dialogue. The direction ultimately received was to include new wells as part of an operator's financial assurance plan and not call them out or treat them differently. As a result, you will see there are changes to Rule 218. Staff had proposed in December that new wells would be bonded up on transfer. And that piece was subsumed by subsequent commission direction that we'll work through. So again, new wells are now considered as part of financial assurance plans, and that will be integrated into the 702 language. This slide had a number of kind of softer directions. A number of them are related to different components. The one that didn't is kind of not using the word tier. So we moved the 702 financial assurance tiers and started calling them options. So I will try to be very disciplined today and say financial assurance option instead of tiers, but habit might get the better of me occasionally. So and then the options that the commission ultimately created are on the following two slides. An individualized plan option, 2 blanket bonding options based on production thresholds, 2 blanket bond or 2 bonding up scenarios where an operator is ultimately going to bond up to their total single well financial assurance for all of their assets over time. And then a 6th category of a comprehensive bond. So bear with me as I work through some rule language now. There is this additional slide where we talked about some other approaches to financial assurance options. Ultimately, that wasn't the direction, but I've maintained that slide. And then working through some of the other components of what's going into a financial assurance plan and how they're updated. I kind of lumped all of these topics together because once we get into the regulatory language, it flows better. So I think, again, and as we zoom back out, again, 4 of the 6 financial assurance plan options are built around a BOE or MCFE threshold. How that's calculated and how it's applied is incredibly important. Because I think the intent of this commission is to have operators who are what we think of as oil producers use a BOE threshold, and operators that we think of as gas producers use the MCFE threshold. Keeping in mind that the BOE thresholds are higher, they require more production than the related MCFE threshold for a particular financial assurance plan option. They're not a 1-to-1. If they were a 1-to-1, we could just use BOE or MCFE. With that, how we have recommended calculating the aggregate gas oil ratio for an operator to determine whether they're, for purposes of 702, using a BOE threshold is again taking their aggregate production across all of their wells, dividing MCFE by barrels, multiplying by 1,000. Above 15,000, you're going to use the MCFE threshold. Below 15,000, you're going to use the BOE threshold. But under any scenario, operators who have mixed production streams get credit for both types of production. I have not recreated the whole slide from staff's presentation here. If you want to go back to it at any point in time, let me. So this again, in the intro language of 702C is our attempt to make sure that we're applying the right criteria to the right operators If I've misinterpreted how to do that, please let me know and we'll get it corrected. From that, that sets the foundation then for looking at the different financial plan options. So again, and within the commission's direction, there was some direction about reordering the options. So we're starting now with the 2 blanket bonding options in option 1 and option 2 based on production thresholds, either BOE or MCF. Option 1 and option 2 are fairly straightforward. As we move into, again, option 3 and option 4, there are also BOE, MCFE thresholds. There's 3 and 4, and then 5 is the concept around an operator creating an individualized plan. The direction around that was warranted based on undue hardship. That language, the undue hardship language, is here in 702C, not 702D, which are the informational requirements associated with a particular financial assurance plan. So I wanted to call that out in the last line of paragraph 5 on the screen. Option 6 is a financial assurance plan that would allow for a comprehensive bond. We've added language to try to describe what we mean by public company. I think that was the intent. One of the directions from the commission was that an operator pursuing an option 6 plan would be subject to review every 5 years. This is something that if the commission wanted to change in the order approving it, you certainly could, but that was the initial direction that we received last month. And I would note that for the plans that are reviewed by the commission, which are 3 through 6, you will have the opportunity to set, based on the individual circumstances of each application or each plan, the regularity with which you, the commission, would like to review it, as compared to how often, staff will be conducting annual reviews no matter what. The last piece on this slide, and I didn't know exactly how to call this out, so it was paragraph 7 and it fit on the slide, but we did have discussion about the related operator consolidation, and so we've included that language here. I think also in the insurance related language in the rule number that's escaping me, like 705. So just wanted to flag that that's here. If ultimately you will decide that that's not the direction you want to go, we can pull it out, but I thought I heard tacit support for staff's recommendation to include it. Turning now to 702D, and this is the meat of the financial assurance plan. What is coming in for review by the commission, by staff, and by the world at large? Again, option 1 and option 2 look very, very similar. The rules themselves include the proposed blanket amounts as recommended by the commissioners. I didn't want to recreate that here because I didn't want to have 100 slides. I think the important distinction between option 1 and option 2 is the inactive well distinction. The blanket bond for an option 1 operator covers up to 10% of their inactive wells. In contrast, for option 2, single well, the blanket bond covers up to 5% of their inactive wells. Any number of inactive wells above those, either those the respective threshold, will require single well financial assurance for those inactive wells. Turning now to option 3, we don't need to worry about inactive or non-inactive in terms of calculations, because in both option 3 and option 4, the operators are on a path to provide single well financial assurance for all of their wells. It's a matter of time. And so that's where the third bullet point in both option 3 and option 4 really distinguish from option 1 and option 2. And again, you'll see it here in option 4, the time to submit total financial assurance. Option 5, largely the same informational requirements. We did, based on the direction from commission, to look at kind of the EPA related criteria for requesting an individualized plan, include a requirement to have a certification of financial capability signed by a corporate officer that would include the operator's net worth, and an accompanying unmodified opinion issued by an independent auditor to get an understanding of the financial picture without, to me, this threads the needle, or the challenge that I think we've all discussed over the last hearing days, of what is our expertise when it comes to evaluating financial capability? Given we thought this might be one way to approach that question. So we recommended it based on your direction to look at those EPA criteria. And then option 6 is pretty straightforward. Information requirements, financial assurance amount, and then the types and methodology. And that rounds out some of the heaviest lifting that these rules do in 702C and 702D. Turning now to some kind of related issues. I think there were a couple of different slides that ask staff to make sure that cash held by the operator in a financial assurance structure could be invested in something that creates reasonable risk. As we looked at the different financial assurance instruments, methodologies, options, types, depending on which word I choose to use at a given moment, the only one that really leaves cash with the operator is the trust fund concept. And that's why we incorporated a definition of a third-party trust fund and also included the idea around reasonable investment. One of the other directives was making sure that staff is validating with the surety company that the surety is still offered. I am going to talk more about this concept later, but we've built that into 707A1C. And then as you saw in the 702D plan language that I've worked through, the commission directed flexibility in the type of financial assurance provided under any of the financial assurance plan options. And so that is why 702D is specific about wanting to know how the operator proposes to provide financial assurance, but isn't prescriptive about which ones are available. With that, we're going to turn into financial or element 4 around reviewing financial assurance plans. And the language incorporated here spans both 702B and 707. So turning now to 702B, this really contemplates the timing for initial plans and revised plans. And so for existing operators, what staff has recommended is that operators with 50 or more wells need to submit a financial assurance plan by July 1. Operators with greater than 10 but fewer than 50 wells, October 1 of this year, and operators with 10 or fewer wells need to be rolled in December or on or before December 31st of this year. Again, that December 31st date lines up with the close of the amnesty program. So I think that these pieces come together in a way that helps us transition successfully from our current state of financial assurance to our future state of financial assurance, largely in less than a year. And so I think that's kind of amazing. And our team has a lot to do on the implementation side. In terms of financial assurance plan review, once those plans are submitted, 702B1 directs that the director can review options 1 and 2, right? Those are largely prescriptive. Does your production meet a particular threshold? Do the math on what your blanket bond amount, and then do the math on what your single well financial assurance is for inactives over your respective threshold. Options 3 through 6 require a commission hearing based on the directive that we got. Rolling into option 3, it's a clarification that new operators, if you're filing to be an operator in the state of Colorado, you need to come in with your financial assurance plan. And then revisions to financial assurance plan. Operators need to file a revised plan based on change in circumstances. Again, the director can review it if it's 1 or 2. Commission will review plans submitted pursuant to any other option. Tying the director's annual review in 702 to the more lengthy, more robust language in 707. The director can require to file a revised financial assurance plan here. And again, we're trying to make sure that our different provisions talk to each other and we're providing clarity. So I'm going to do a little bit deeper dive on point 2, which is why we've recommended the timeline that we have. We pulled the data on what that looks like from a workflow standpoint. And so right now, using the 2020 operator data, which is a separate spreadsheet than what we made available on the commission website and the financial assurance hearing. So this well count, these operator counts include federal wells, which is more consistent with your direction, the data, just as a heads up. So operators with 50 or more wells, it's due July 1, 62 plans, which is 16% of the plans, but it covers 95% of Colorado's wells. And that to me is outstanding. B, we're going to roll in operators with greater than 10, fewer than 50 wells. Again, 22% of Colorado's well, or 22% of Colorado's operators, 4% of the wells. And then closing out in December, 237 plans, which is 62% of the review, and 1% of the wells. I think that this workload makes sense. It lets us again transition most quickly a large share of the wells. And it also lets us learn through the process without getting 200 on the same day. And I know that the commission talked about maybe flipping that. And if that's the direction, obviously it's fine. I just thought it'd be helpful for you all to see what I saw when I looked at doing this. Turning now to the interrelationship again between submitting plans and reviewing plans. So 707A1 lines out the non-discretionary annual review by the director. What we're looking at, what we're evaluating compliance for, and what can come out of that process. I think that we talked earlier about C, right? The director verifying that sureties remain in place. I think this is, us auditing, making sure that the plan option still fits the operator. Turning now, there is also a discretionary review component for the director. So if we have concerns, we know that something has changed on the ground outside of the annual review process, we can also take a look at a financial assurance plan and whether the option still fits the operator. 707B covers the commissioner's review. And again, B1 encompasses the frequency with which you direct and commission order these types of your specific review of financial assurance plans. In addition, the commission has a discretion on its own motion to take a look at it. And then I swapped 1 and 3. So 3 is a commission order. Right now, the commission order can say, if you approve a financial assurance plan, you can set the cadence with which you would like to review it. So just so you know, there's large discretion. There's not a mandatory circumstance it requires review based on 707B. That said, if an operator submits a revised plan under options 4 through 6, that is coming to the commission, right? Staff does not have the discretion to review those plans. So there are a number of different mechanisms that result in this commission having the opportunity to take a look at a financial assurance plan option. Okay, so rolling into reviewing transfers. And again, this is a space where I think that there is probably going to be robust conversations from stakeholders, from commissioners going forward. The ultimate direction that staff received is that single well financial assurance would be required for any well transferred after April 15th, 2022, which is the anticipated effective date of these rules. And so jumping straight into that language, 218B5, I think A covers the intent and the purpose, with the one exception that the commissioners articulated, which is the like-kind exchange transaction between the selling operator and buying operator. Again, B, C, and D remain other components of financial assurance that would be at issue in transfers. I wanted to take a minute to walk through 218 and the process, because staff did build in a couple of different components and wanted to call out a couple of components because the commission had a fair amount of discussion about what happens if a buying operator doesn't bond up. What do we do? How do we do this? And so as you'll see on my next slide, I'll talk about kind of closing that loop. So 218A defines the transferable items, what's going where. 218B requires a selling operator to send in a Form 9 initial that provides specific information about this. And it includes the estimated amount of financial assurance the buying operator will be required to submit, as well as the anticipated impact on the buying operator. I'm sorry, that should be the selling operator's financial assurance. There's a typo in B. So again, as part of the Form 9 initial, we're getting information about what the financial assurance is required, what new financial assurance would be required for the buying operator, and also what information, what impact this will have on the selling operator's assets or profile. 218C requires the selling operator to submit a transfer fee. We've not imposed that fee, so it's right now $0. 218D is new language, and it requires the buying operator to submit the estimated amount of financial assurance prior to the transfer. This is consistent with other language throughout the rules. We thought it made sense to very explicitly call it out here because it was implicit based on the reading of F and G below, and wanted to set the expectation that clearly. So then Rule 218E requires the buying operator to submit the Form 9 subsequent that provides information about the completed transfer. 218F and G talk about what the director can and can't do in these circumstances. 218F says the director will approve the Form 9 under certain conditions, one of which is that the buying operator has submitted the financial assurance. So the failure to submit financial assurance means the director, especially if you read G, will not approve Form 9 initial and subsequent. So those are important, again, mechanisms as we're thinking about how to implement this. Rule 218H currently authorizes the director to require shut-in of wells that have been transferred but have not received adequate financial assurance. We have started to exercise that authority, but what that language didn't do, that the language in 218H proposes to do, is find a path out of the shut-in status. And so with advice from our wise attorney generals, and I'm going to get to that language shortly, we've proposed language that would help unfurl that unfortunate circumstance. And then 218I and J relate to what happens, dictate that the commission or the director cannot approve a Form 10 until the Form 9s are approved, and that a Form 9 is not required for gas gathering, gas processing, underground gas storage facilities because they're covered in different rule provisions. Okay, so getting back to the 218H, again, kind of closing the transfer loop. What happens when the wheels totally fall off the bus? Again, 218B, 218D, 218F requires submission of financial assurance prior to transfer. That's exceptional. 218H, as proposed in subpart 2, allows the director to seek a hearing before the commission with the buying operator and selling operator to sort out who is going to be the ongoing operator. This is important to me because if we have a transfer that has taken place in the private sector and cannot be completed in our records, we have the situation where, and we face it now, the buying operator has legal access to the site but can't file forms with us, can't update us, can't communicate with us about those facilities. And so we need to be able to close this loop quickly. I think as we look to other rule provisions to talk about how to build out this process and this closing the loop, 701A describes the commission's broad interest and control over financial assurance. And complementary to this, Rule 706A2, which covers when financial assurance is returned. 706 generally covers when financial assurance is returned to operators. 706A2 very specifically contemplates the transfer situation, and that it's not returned to a buying operator until the selling operator has completed, or we have completed the Form 9 process. So together, I think those provisions help unfurl the loop we're in. And with that, I'm going to turn it over to Ms. Stafford for just a moment.
Thank you, Director Murphy. So you see a slide before you that sort of sets forth the proposed Rule 218H2 and staff's purpose in proposing this particular rule. Based on discussions during party presentations and the following commissioner direction, staff has proposed new Rule 218H2, which allows the director to seek an expedited hearing if a situation occurs where a buying operator is unable to bond up and the selling operator is unable to maintain adequate financial assurance. This rule is intended to protect the commission in the event that neither operator can comply with financial assurance requirements, and also guarantees the regulated community will receive due process and full procedural protections if and when the director initiates such hearing. It creates a targeted and streamlined process of commission-only review, and it takes advantage of Senate Bill 19-181, creating the full-time commission, which means that you as commissioners will likely meet frequently enough to quickly address this category of expedited hearing. Now, as I've discussed with you before, the Colorado Administrative Procedure Act governs the legal and procedural requirements agencies must follow when conducting adjudicatory actions. Via this proposed Rule 218H2 and 503G11, the Commission is providing robust due process protections by authorizing an expedited hearing directly to the Commission, rather than the ordinary process before an administrative law judge or hearing officer. This direct process affords operators the full notice and opportunity to cure required by the Administrative Procedure Act before any action is taken by the Commission. As is true with all Commission hearings, each involves notice, a reasonable time period to prepare, and an opportunity to be heard, which meet the requirements of the Administrative Procedure Act. Now I'll turn it back to Director Murphy to discuss the next element in the presentation.
Thank you, Caitlin. Well, let's see if I can get my computer to work with me. Okay. I promise we're in the home stretch there, like I think 13, 14 slides left. So thanks for bearing with me this morning. Establishing an out-of-service wells plugging process and plugging timeline. I think the most important direction, or the most concrete direction, was to put together a strict identifiable deadline for plugging in rule language, and to work on this direction with stakeholders. I forgot what my next slide was, sorry. And what we were able to accomplish in terms of stakeholder engagement is having a brief conversation with the operators involved, who I think are largely okay with staff's proposed language. I've had a couple of conversations, but I haven't had the opportunity to follow back up around staff's proposed language with some of the other stakeholders who have engaged on this issue. I think one of the other pieces that the Commission wanted a little bit of guidance on was the inspection of out-of-service wells prior to plugging, AIM versus the instrument monitoring required by CDPHE's Reg 7 versus the audiovisual olfactory proposed in staff's December draft rules. I am going a little bit out on a limb here to talk about my understanding of the regulatory regime that CDPHE has recently adopted as it relates to using AIM inspections for wells and how that would integrate with out-of-service wells. So Reg 7 Part D Section 2E requires AIM inspections of well production facilities on a periodic basis. So if a wellhead is on the same pad as production equipment, it's part of the facility being inspected using AIM. Then the underlying question of, does Reg 7 Part D subsection 2E apply to shut-in or temporarily abandoned equipment? And this question and response is taken directly from CDPHE's PS Memo 14-4 Section 6, which states if a well production facility is shut in for a period of time, do AIM and AVO inspections need to be performed? And the answer is, during times when a facility is shut in, any pressurized equipment that contains or contacts a process stream with hydrocarbons should still be inspected according to the required frequency. My understanding from communicating with CDPHE is that, shut-in wells certainly do fall within their AIM inspections if that shut-in well is co-located with a production facility. On the leak component, so what happens if there is an AIM inspection? What happens next? Leaks above certain thresholds require repair, and the repair timeline varies, and in part depending on the proximity to an occupied area. So if a leak above the threshold is not within 1,000 feet, the first attempt to repair must be made no later than 5 working days after discovery and completed no later than 30 days after discovery unless parts are unavailable. The equipment was required to shut down for a complete repair or other good cause. For a leak above a reporting threshold or within a response threshold, within 1,000 feet, the first attempt must be made as soon as practicable, but no later than 5 working days. And kind of again, if it's not completed within 5 working days, the operator must use other means to stop the leak. So I wanted to make sure we understand the complementary to the extent that I can represent it, and we can pull in somebody from CDPHE too if you want to have a deeper dive. I think a number of our stakeholders have been deeply involved in development of this regulatory language, so they may be able to respond as well. But I wanted to at least share with you my understanding of these requirements and how it would relate to out-of-service wells in an AVO inspection process. So that's kind of the, like, please help us understand this answer. If we kind of roll back into how we put the out-of-service well process and plugging timeline together, we've built that really into 434D. I think that there are a couple of pieces that could continue to receive refinement around prioritization or noticing engagement. And that was something that I really didn't have a ton of capacity to get through in terms of what does it really mean to prioritize or engage. I think that there are other, anyway. So I'm going to roll now into 434D. I've again summarized that language instead of trying to put up multiple pages. Where big picture staff landed is really focusing the out of service well list and plugging list on plugging. Staff's more recent drafts had kind of broadened it out from plugging to also include reclamation, remediation components, which would draw out the timeline for removing wells from that list. And so we instead took a very focused approach on getting wells plugged, which I think is a priority of the program and really the fundamental purpose of it. And we worked with stakeholders to have the 6A come in with the initial financial assurance plan is the preferable option for this first year. And that 6A immediately designates a well as out of service. There's not a director review component of it. We have in paragraph 3 specific information requirements for the form 6A. So think of the 6A as how we add wells to the list. The 6B is how we report about them, and approval of the 6 subsequent is how a well individually gets removed from the list. So those are kind of the 3 mechanisms for moving information around. So paragraph 4 of 434D sets out that plugging and abandonment of the well and commencing reclamation and remediation if necessary removes the well from the plugging list. Again, that's that form 6 subsequent. This provision also directs prioritization of work in disproportionately impacted communities and sets the specific plugging deadlines. Staff largely utilize the language suggested by Matt Sura with one change, which is for wells added after the initial submittal of financial assurance plans receiving 4 years, not 3 years for plugging. I think subparagraph 6 incorporates Westlake Koga's requested language that hydrocarbon production for depressurization immediately prior to plugging doesn't remove, if you will, the well from being an out of service list. And that is actually 5. I have a typo on my slide. Now I'm wondering where 6 and 7 are, but it'll be fine. I'm gonna roll with this. And then the form 6B is the operator's annual report on what they're doing, what work is taking place on out of service wells and facilities. It has specific criteria of action to be taken at different locations, and the operator can report yes, no on those. It also requires specific reporting about wells plugged in disproportionately impacted communities or in proximity to building units, schools, within childcare facilities within disproportionately impacted communities, and also activity within the 1202C habitats. For those who don't remember 1202C as well as I do, it's the most protected, if you will, wildlife habitats based on our 1200 series rules that were adopted again in November of 2020. They can be thought of at times as the no surface occupancy habitats. I know that some stakeholders have requested that operators report out about plugging activity in all high priority habitats. My concern is that there is a lot of high priority habitat in the state of Colorado, and I would rather focus on the places where we think it's most impactful to get wells plugged and return that surface to wildlife habitat. Next is subsection 8, which provides a director's discretionary review of plugging lists. It's to me plenary. It's also gives me the flexibility and the tools that I think I need to ensure that one, a list is implementable by an operator, and 2, progress is being made when we look at the 6A or the 6B. So I think it's an appropriate tool. 9 clarifies that transferring a well does not allow repurposing it for a different use, and that the same deadline for plugging applies, subject to Rule 218, and that repurposing an out-of-service well may be permissible for uses other than hydrocarbon production. So that, to me, really closes a loop that says we expect out-of-service wells to be plugged unless you're using them for something other than hydrocarbon production. A consequence of failing to comply with the plugging and abandonment deadline is requirement to immediately provide single well financial assurance for any or all wells that miss the deadline. The wellbore integrity language in paragraph 11 covers that bradenhead monitoring and testing will continue to occur at all out-of-service wells as required by the 400 series. MITs are required under 2 circumstances: if the director requires it, or if the well is not equipped with bradenhead access. And staff's recommendation has continued to be annual AVO inspections. I think that CDPHE has spent a lot of time developing an inspection regime incorporating AIM, and we can complement that with annual AVO inspections. In paragraph 12, it's clarification that the out-of-service rule does not apply to gas storage wells. A couple of related changes. Again, we modified the definition of out-of-service well and the definition of plugging list. We eliminated the definitions of out-of-service location and out-of-service facility because, again, we're trying to have the plugging list and the out-of-service well designation focus entirely on the wellbore and getting to plugging and abandonment. And to be abundantly clear, even if a well has been designated out of service and has been plugged, the location remains subject to the applicable 900,000 series and any other relevant rules. And also the removal of a well from the plugging list doesn't, is not a trigger or a criteria for release of financial assurance. So again, I think that this is appropriately targeted on what the ultimate goal is, which is to get shut-in TA'd flow producing wells plugged by the operator. And then I wanted to touch briefly on the language in Rule 218B3C, which makes clear that transferring an out-of-service well does not relieve the obligation of plugging the well. However, it does provide some discretion to the director to modify the plugging deadline if the buying operator is merging plugging lists. And again, this is about making sure that we're achieving the overarching goal, which is getting the right wells plugged at the right time. And I think I can go back. I can hear Commissioner Gonzalez in my head talking about the importance of making sure that we're scaling the work to best capitalize on mobilization costs or other pieces around that. So that's, to me, the out-of-service well process and plugging timeline that implements the direction from the commission and is a lot of information. Turning now to the other topics and elements. So 703 was around remediation projects, and there was no recommended changes. 704, there were recommended changes for surface owner protection bonds in terms of the per acre amount and eliminating blanket bonding. So turning first to 703B, I wanted to go ahead and pull the language up that's proposed by staff so that everybody can take a look at it. And then also flag that 703 covers a number of other topics that are important for financial assurance, E&P waste, centralized E&P waste management facilities, seismic, gas gathering, gas processing, underground gas storage, produced water transfer system, and commercial disposal facilities. I probably should have talked about this when I discussed the different financial assurance plan options. One wrinkle or question to work through is the relationship for a commercial disposal well operator who only has commercial disposal wells, how those wells fit into the financial assurance plan options. Those wells will have zero associated hydrocarbon production. And again, this is for operators who only have a commercial disposal well facility. Commercial disposal wells. Those operators will have zero production, therefore they will fall into option 4, or can also request an individual hearing. If that's the approach that you all want to take, that's perfectly fine. But that's one of the challenges of using only a production threshold, because there are a few, I think like 25 operators. I think that might be an overestimate. I have the data, I'll try to pull it up quickly, who have only gas or disposable facilities. So again, trying to keep in mind how some of these different pieces fit together. Turning now to the 704 language on surface owner protection bonds. We made the changes to eliminate the blanket bond and double the amount per acre. I have not included the remainder of 704. There is a lengthy discussion of the process for claiming a surface owner protection bond and how that works. I don't think we made many changes to the language that exists today throughout the different process, except to clean it up. And then covering another list of important topics. I'm going to run through insurance, releasing financial assurance, the definition of surety or surety bond, and then some of the cross references. One thing that I will flag is, as we were working through the rules, I lost track of the commission ask to have a better understanding of how release of financial assurance occurs now and what improvements could be made to facilitate the process. I think we have a lot of work to do internally on that more than anything else. Some of it is getting good work in, some of it is a capacity problem for us. But I think that Rule 706 as drafted sets out the right process, and we can manage to that and can do better. If you want a more formal presentation on that, I can make it happen, just probably not until after the 24th of this month. But wanted to note that I lost track of that request over the last 10 days. So now jumping in back into the substance of the rules on insurance, we, based on commission guidance, built in the expectation for environmental liability into the general liability provisions and set the amount at $5 million. And then require, demonstrated compliance with the Form 1, which is coming in annually. I'm sorry, with the Form 1, and then operators can provide notice of any renewals or changes on their Form 1B, which again, we're going to be collecting in August of this year, and then moving forward April 15th. So that's insurance. Again, turning to release. This is an important topic. The director will release when the operator has fully complied with all statutory and regulatory obligations. It provides a procedure for claiming financial assurance. It provides a procedure for identifying recalcitrant bond providers and for a recalcitrant bond providers reinstatement. And also, if we get to the point where we have orphaned an operator's assets, claimed financial assurance, in the event there is some amount of financial assurance left over after that process, clarification that it will be refunded and how it will be refunded. So again, those are really important provisions. They have not gotten a ton of attention, but I think it's worth calling out how that works today as we're coming to a close in this process. And then turning to the surety bond question, one of the directions from commissioners was to check into what the surety company's recommendations had been and whether we had implemented them in staff's draft. And I have to give credit to Ms. Stafford. She did the lion's share of the work on this. I'm going to try to summarize it, which is the last sentence in the definition of surety bond made the surety companies queasy. In particular, the focus on this version shows staff's proposed revised draft, which came out on Friday. Before the 11th, or before the draft that came out on Friday, it said the surety bond has no contract or property interest in the surety bond. Staff, based on dialogue with the surety companies and also our bankruptcy counsel, has recommended that we eliminate the reference to contract, but maintain the remainder of that sentence. And I'm sure companies or others can provide further input on that and whether that is not their preferable outcome, but they can live with it or not. But that's kind of closing the loop on us implementing concerns expressed by the surety companies. And then talking about a couple of conforming changes, again, conforming changes and other provisions that we haven't really talked about. Rule 223 covers confidentiality provisions for confidential business information. 304 and 306 are conforming changes around the director's review of financial assurance and permitting processes. Rule 413, we conformed, clarified, and updated the Form 7 monthly production reporting. And again, these changes aren't new to what came out on Friday. It's just making sure. I wanted to talk briefly about these topics to understand how this complete picture comes together. Again, 436 and 810 make conforming changes related to seismic operations and commercial disposal wells to complement what's being proposed in the 700 series. And then in the 900 series, staff's June draft provided kind of an entirely different financial assurance process specific to remediation projects. As we worked through the process, we ended up integrating that into the 700 series and in particular into the 703B language that I showed earlier. But just wanted to kind of tell the story about why it looked like there were a lot of changes to the 900 series, but ultimately there are not going to be a ton of changes to the 900 series based on the, or the February 11th draft set of rules. So conforming changes. And then I wanted to close talking about Rule 701, just because I think it's something that hasn't been discussed very much, but covers a lot of really important ground. First, what are our preferred types of financial assurance? A cash bond, a surety bond. These are the easiest in staff's experience to work with if we are in the unfortunate circumstance of claiming the bond. It also sets out that the commission can request a hearing to approve other types of financial assurance. And so I think that that's important to note, that understanding how 701B works with option 1 and option 2. So if an operator is proposing an option 1 or option 2 plan, and they're proposing a type of financial assurance other than a cash bond or surety bond, they will need a commission approval for that. And I think I didn't have direction on it, and so I didn't make many changes to it. I think it's for the 5 of you to work through whether that's the appropriate relationship. But it is an important consideration. I think 701C, the commission's interest in active financial assurance, is a very important piece, especially C2, when we go back to this conversation about what happens if a transfer is unsuccessful and a buying operator fails to post financial assurance. This is part of that complete package to make sure we have the authority and we are able to exercise it in that circumstance. Folks have expressed concern about riders. Staff feels the same way. And so we've built in a provision prohibiting riders. If we want to talk about what they are, I need to call somebody else briefly. But I know that the concern that we heard expressed early on in the process from staff was enough to make sure that we built out a process that doesn't allow for and has an off-ramp for existing riders. And so I think this, to me, again, 701 kind of encompasses the total picture. What does this do? How does it function? And that, to me, is the right way, after doing this deep dive into the rules, to come back out to where we started, which to me, when I look at these rules on whole, recognizing that provisions will continue to evolve in the coming week, I think that at the macro level, there is a huge paradigm shift in how we have approached Colorado's financial assurance. This is a multi-layered approach, right? Like you all worked with me and my passion for these different financial assurance elements to try to build them into a picture or a Venn diagram that complements each other and recognizes risk in different ways and responds in a tailored way. And I think for me, it, again, if I come back to where I started, which is, for me, it incentivizes operators to satisfy the obligations under the acting rules. That is the ultimate goal. If we're claiming financial assurance, something that's gone off the rails, and it's not my preferred option, right? Industry in Colorado has plugged 47,000 wells and Orphan less than 1,000. That is something we want to maintain, right? And so that to me is the importance and the benefit of actually using that operator, the operator's aggregate production threshold to think about and approach financial assurance and blanket bonding. And as the production declines, operators have choices, right? They can move into a different option of financial assurance that increasingly becomes more expensive and ultimately puts them on a path to providing single well financial assurance for all of their assets, or they can drill wells as an option to maintain production, or plug declining assets, right? Their lowest producing wells, taking them off the list necessarily changes the balance of the overall production threshold. So I think that that's a very nuanced approach, and commend you all for coming to it. And then I think, again, as we put the financial assurance Venn diagram into the entirety of the other rules that have been updated, we are implementing the consideration and direction of Senate Bill 19181 in this financial assurance rulemaking, and it is a piece within the broader mission change shift required by Senate Bill 19181. And so I think it's just a testament to the work of each of you. And with that, I am done. So, and we can just call it good there if you'd like, or I can answer questions.
Thank you, Director Murphy. Very comprehensive. Really want to throw out appreciation to you and staff for all of the great work that you have done in implementing some of the direction that you received from the commissioners. Lot to go through. I assume that the PowerPoint will be posted so that everybody can have access to it. I know that I want to sort of take the PowerPoint, take the draft and sort of spend time with it. But does any commissioner have questions at this point for the director or AAG Stafford? Commissioner Messner?
Thank you, Mr. Chair, and thank you, Director Murphy, AAG Stafford, and all the staff that have taken, a pretty diverse set of thoughts and deliberations and put it into something concrete that we can continue to work on and deliberate and evolve here over the next week or so. So I appreciate the work that's gone into it. I did have a couple of questions just to make sure that I understood a couple of things. One was the consolidation definition. And I think at one point, I had asked the question, and I think that we had, I think industry actually had come back with a revised definition that indicated that that in consolidating under a parent company, the subsidiaries determination for financial assurance considerations, that they would be required to consolidate all of them and not partial. And it didn't appear that that was captured in the definition, although I may be reading it differently. So didn't know what your thoughts were on that, or whether we were clear with that or not. So just that was one question. I can ask all my questions at once, or I can go one at a time, whatever you prefer. I only have three. So
okay, I think that one, Commissioner, we can take a look at, but it might be something that we need to tweak in the final deliberations. It's a good catch.
Okay. Well, I think I actually have answered this, but the reclamation requirement in the out-of-service well proposal, it does indicate that they do have to start reclamation, right? Within that time frame, and then the finality of that reclamation would fall into another rule set that would require that reclamation to actually be completed in a timely fashion, but it just wouldn't be required to be completed in the OOS timeframe. That's correct.
Yes, Commissioner Mesner, the 1000 series is specific about when reclamation must be initiated and worked through. And again, it has a, performance-based expectation. So it may not go as quickly as we all would like at times, but it needs to achieve those final thresholds.
Sure. Okay. And then as you were kind of evaluating Reg 7, the AIM requirements, and then kind of making a determination to continue with the AVO annual requirement in our rules, I think one of the topics that was brought up was just a notice requirement or letting COGCC know if there was a leak detected through the AIM process. And I mean, was there, what is your take on that?
It's a couple of things. I have explored with stakeholders that concept of, having it reported to us either if it's not repaired in, the 5 days or the 30 days or how it works. I think that my understanding of the reporting is that it would be an independent reporting component separate from what's required by CDPHE. So it would be a different process. And then thinking through what our response would be, given that there is an existing repair requirement established by CDPHE. So there's some tension there for me. I think that it could be good to know. I wouldn't be opposed to it. I had suggested, to stakeholders, maybe we get reports out if leaks aren't repaired within 30 days. Is that an amenable kind of place to kind of land this? And I hope, stakeholders are continuing to talk about it and think about it and may be able to kind of work through that as a potential outcome.
Okay. Those are just some clarifying questions that I had. I mean, certainly lots of information to absorb, and I look forward to talking with stakeholders and other commissioners during deliberations over the next week. So thank you for the work.
Other questions from commissioners? Commissioner McGowan?
Thank you, Mr. Chair. And sorry, just to follow up on the AIM versus AVO. If I'm understanding your description correctly, I feel like one of the things the stakeholders were bringing up was that the reporting over to CDPHE was just this aggregate list, and I couldn't tell if things were getting repaired. It seems to me that what you're saying is in Reg 7, the operator has, depending on what situation it is, about 5-ish days to repair the leak. So that is getting caught over in the Reg 7.
My understanding, and it's dangerous right now, I'm like at the outer edges of my understanding, is that yes, the repair requirements are in place and that reporting about leaks detected is an annual kind of macro look across the operator's operations as compared to getting individual notices or individual updates about the outcome of that process.
But we don't feel like there might be wells lingering out there that are leaking for a long time after the AIM test and detection of a leak.
I have heard mixed things and it's all anecdotal. So I think that I should stop with kind of what I know.
Okay, thank you.
Further questions? All right, well, thank you again, Director Murphy. Thank you to staff. Thank you to AAG Stafford for the great work. I think we've all got a lot of information that we need to be looking at. I know that we have 95 participants that are listening in, so they will be looking at this as well. We continue to plow forward with regard to this important topic. And so with that, I think we'll look to get the PowerPoint posted to our website and delivered to our stakeholders, and everybody can spend time with it. And we will look forward to meeting again. I believe we will hear from our stakeholders this Thursday and Friday, and then we will finalize deliberations next Tuesday and Wednesday. Noting that we also have a meeting on Wednesday morning. So anything further from anyone for the good of the cause? Seeing none, and this is part of our financial assurance rulemaking. I am calling upon AAG Davenport to make sure we do this correctly, but I believe we would look for a motion to continue this matter to Thursday morning at 9 a.m. Is that right, AAG Davenport?
I think just adjourn, Mr. Chair, adjourn until Tuesday. Yes, whenever Thursday morning at 9 a.m.
So we were looking for a motion to adjourn until Thursday morning at 9 a.m.
So moved.
Second,
Motion and a second. All those in favor signify by saying aye.
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 Any opposed? We are adjourned on the financial assurance rulemaking until this Thursday, the 17th at 9 a.m. Thanks, everybody.